Yes.
I may pardon to mention, your lordship, item 38 and 48, appellant already expired.
Do you have any report?
Yes.
Huh?
Yes. From engaging counsel, I have received the information.
I'll give you 38
And 48.
And counsel for the appellant admits that he has got instruction from the briefing counsel and the family of the appellant that the sole appellants, in both the cases, sole appellant?
Yes.
38, 38. Let us see first 38, Yes, 38. Sole appellant 38 relief, sir. Sole appellant Birendra Kumar Sahu. Has expired. In the absence of any application, also it stands abated. And next is 40,
48.
48, okay. 48, sole appellant Lipton alias Lola Tendu Pradhan. It expired. Stands abated. Okay?
Obliged.
Thank you. Yes.
Item 1.
Need a little
Yes,
bit that modification with regard to address. In the PR as well, the rejection order, the address is wrongly reflected. In fact, that the district will be Jabalpur. The consulted cost title. Only this much.
What are you seeking?
In fact, 2510 bail was allowed. And since the district Jabalpur was issued as Damanpur, for which person could not able to avail the benefit of the order, past bail also.
Okay. As order, change period.
I filed the consolidated cost title.
Consolidated cost title also taken on record and change. Okay. Yes.
Item 2.
Application taken for item 2. P. Mohanty, none P. Mohanty. Was appointed P. Mohanty.
This is in conviction under section 498A, 306 IPC and 4 DP Act.
File the way.
Yes. For 306, he has been sentenced to undergo 4 years of RI. For 498A, 6 months of RI. 4 DP Act, 3 months of RI.
So how many appellants are there, madam? How many appellants?
Only one.
Is the husband?
Yes.
Is the husband, huh?
Yes.
Okay. So let us see.
The marriage took place in the 1985-86 and the date of death is 22/4/1989. It is within 7 years of marriage.
No, there was warrant issued.
Pardon?
If something is written warrant or something, none appears for the appellant.
On 10th.
Here is question.
Appellant associate was active. On 13/7/13/11 they had application.
Non-bailable warrant was issued.
That was issued in 1/12/2014.
60 on 1/6/1/12/2014.
Yes.
NBW was issued.
Yes.
NBW is going on.
Thank you, sir. Flag M.
Whereabout and well-being have you got it?
Flag M.
Flag M, huh?
M.
Yes. What does it say?
Accused Swanso has been residing peacefully in his native village, Bonacotta, after second marriage with his family members and doing cultivation in his So he's alive and very much available in
Family?
his village.
I'm not doing cultivation. Considering one son in the toughest line in the working group. Prosecutors has study. If that is the report, NBW is still standing. Why have you not executed?
Yeah, I'm just checking whether he has been arrested in the meanwhile and granted bail.
Because see, the NBW order even today stands.
Yes. 106 has not yet been given.
Rather, 3/7/2024, the order is instead of further pursuing the earlier orders, 1/12/2014, it is now ordered that the
What about?
additional standing council shall obtain the instruction. Then you got the instruction.
Yes.
Thereafter, Mr. P. Mohanty appeared. P. Mohanty and Associates appeared.
Seems 112/14 order has never been given effect.
Who is Mr. P. Mohanty? Paper book, extra paper book is there. Just see.
A is my
Huh?
the Wakalat Mama name reflects A.
Ah,
He has been
long way.
Prashant Mahanti and D as well.
He's the husband, huh?
Yes.
So conviction is under section
490, 306 and 4D.
and the total substantive sentence
4 years.
4 years. Just give me the Mr. Ponda. Just check. Now you have to assess. Okay. Just note it down so that partly I'll hear it. Everything is there. Yes. Because there is indication that no adjournment will be given. If 91 matter, if we keep on giving adjournment,
Worship can so that they can go through the brief.
that also can be done. You can take the file. For your experience, what 2 minutes you'll take. Just read it. You have that much experience.
Next,
Huh?
you did the Thursday.
No. I will.
Yes.
Today only.
Yes.
After lunch, if you
Yes,
want, I
yes,
can
yes.
keep it.
Yes.
But just take the files. Just note it down. See, this is a matter. Incident happened when
9 years.
89.
89.
And keep that also in mind. He is already married second time, and he has a son and daughter. Son is working somewhere. That's the report, and daughter is in the marriageable age. That also you keep in mind.
He must be around
If
60 years.
case is made out, then we can think of sentence modified, something of that sort, undergone period. Just check it up. We'll
Yes.
see. Check it up
After lunch.
after lunch. Check it up. You'll give the file. Just check it up the undergone period. Just madam,
I will.
undergone period.
Yes.
If so, he has 2 years sentence.
4 years.
4 years sentence. 4 years sentence. Then 4 year sentence, bigger sentence. Let it be. We can't take it lightly. Thursday. You read it, huh?
Yes.
Ponda is non-APS for, despite the indication in the cause list that no adjournment shall be granted. none has appeared for the appellant when the matter was called for. Hmm? It will remain, but I'll take it up.
Third.
Therefore, Mr. Amulya Panda, who is present in the court, is requested by the court to assist the court in capacity of MH Keshguri. He has readily agreed for that and seeks an adjournment. Let the matter retain in the board. The same will be taken up on Thursday. Thursday. Paperwork दीजिए संगत.
No, please.
वो एक नोट करने वाले.
He will take it. He will take.
नोट करने.
You have extra paperwork, madam?
I don't have, Your Lordship, paper book has not been
No,
prepared.
no. Extra evidence and all.
I'll be referring. to
From
the
here you
paper
can
book
just read it.
Yes, yes. I will.
Yes. Number 2.
Item 3.
Yes.
Number 3, Your Lordship. There were 3 convicts. And
Report was supposed to be obtained by you. Period already undergone. See, the earlier non-appears for the appellant, I have said 1/7/2025, I have said that period undergone. Then State Council is also directed to obtain instruction regarding the period already.
so I'll
Yes.
take it from here and
How many matters are there? 1. Why is so many files?
item number 3, right?
119.
197. This
Huh?
was a case for
No, this is criminal appeal number.
119.
119. 119.
It is already disposed of.
170 disposed.
107 is disposed of.
Paper book.
There are 3 convicts. Morning Naik preferred the present appeal.
107 is disposed of,
Abated against.
awaited. Okay. Okay.
In that matter, Your Lordship, paper book has been prepared.
Prepared.
Item number 107.
Let us see what are the facts. Undergone period, have you seen it?
17,591 is bail.
119. Only one appellant.
Yes,
Mani Naik.
morning.
Three 304.
Get bail by the Honorable High Court on 17,591.
88. Incident is of 88. Just check it up. TCR देखो यहाँ.
It's 91. इसलिए तो नहीं आई तुमसे
When was he arrested?
इसलिए तो नहीं सही conviction judgment was on April 1991. I got bail on 17/5/1991.
From the Wakalat, now it can be seen that he has been signed his Wakalat from jail.
Jail custody.
No, that is after conviction, na?
Yes, Your Lordship.
Of no, during trial, I just want.
इसलिए तो नहीं सही.
Huh? Is there? Just see the case diary when he was arrested.
TCR is not there.
TCR is there?
No, TCR is not there.
Huh?
Disposal case of paper book.
But TCR, what is this TCR then? Yes. A paperwork is there. TCR is there. अरे उसका TCR क्यों दिखा रहे थे भाई? Paperwork. Ayu, just see Ayu might have said when he is arrested. Who is Ayu? आयु कहाँ आयु को देखो भैया
PW 13.
just see what he say when he has
25/10/88.
25/10/88 when the bail was granted. Just check it up now. 25
26/10/1988.
8 10/88 bail when he got bail 91
From the High Court, yes.
no
17/5/91.
17 5 28 Mr. Ogada, once you enter, you have to take some responsibility also.
I was engaged in an after the council matter, there is no contact, so I appeared. Not after the paper.
But in this matter, the one which I am looking at, this you have to do. Give it to him after lunch. Mr. Raghunath. Paperwork is there. You take the paperwork and read it.
5 year of sentence.
Huh?
5 year of substantive sentence.
5?
5 year of substantive sentence, Your Lordship.
5 year sentence, na? We'll read it.
2 p.m.
2 p.m. 2 p.m. Mr. Raghunath. Otherwise, see, these matters will never be ending. Never ending process. Senior counsel like you people have classes so that we will.
Other some cases.
Otherwise, it will remain like this only.
This matter, I will do it. I don't know 8 percent.
2 o'clock, huh? Yes.
Item 4.
These are the matters, Mr. Raghunath and all of you. I am interested to engage youngsters, but these are sentences are 4 years, 5 years. We can't take the chance.
No, I am ready to ask the court matter. Whatever matter assigned to me up to 2 p.m.
Yes, yes.
Each and
And
every-
all of you should be ready because youngsters, small EC Act, small 5 years, 6 month, 3 month and all, I give it to youngsters to argue. And little more, some responsible should be there. Yes.
Mr. S.N. Mishra is also there.
Yeah, I have been taking his assistance.
Yes, Your Lordship.
Yes.
Item 4.
Item 4, the conviction under section 304B, 498A and 4 DPI.
Sentence?
7 years. For 304B, 7 years. For 498A, 3 years. And 6 months for 4 DP.
So this is Mr. Shyamananda Mahapatra is appearing in this matter. Because he was here only.
Yes.
4 o'clock, he will come, pass out.
The last occasion.
He has been coming every time. Yes.
Item 5.
Yes. दो 5 एक मिनट तो सुन ले
Your my lord, the
You are the proud son to appear for your father.
Lokavandhan still there. After 27 years also.
So let us finish it. I don't want to make your son to be proud again. That he'll appear after.
Here, my lord, is a case where the judgment is based on 161 statements.
161 statement.
Court has taken note of the accused.
Interested witnesses are turned hostile in the.
It's a case of 498-304B. Parents, they turn hostile. Everyone has turned hostile. He has relied upon
161 and convict. Huh?
medical evidence and IO.
Very nice. Let us see that paragraph.
My lord.
जजमेंट कॉपी भी नहीं
Better copy में more पकड़.
3 पेज अच्छी बस नथिंग
वो पकड़े भी नहीं.
नहीं आई गॉट द जजमेंट यस
Hold there. He has taken
para 8
8, my lord. Taken
Para
note of, my lord. In this case, PWs 1 to 3 have been cross-examined by the additional public prosecutor. PW2 has agreed to have stated before the police that the accused, Nakula Janna, had demanded golden bangles. He has taken note of the cross-examination of PP, public prosecutor, additional public prosecutor. PW5, investigating officer, has stated that PW1 had spoke before him that the accused persons were torturing the deceased.
is also stated before PW5 that the so
That he has taken note of.
PW5 was also stated before the police as per the evidence of PW6 that they received the complaint from the deceased sister about the torture for non-giving of the golden ornament, and he is also stated to have lost the FIR during so and so, so and so. I have marked and the demeanor of those witnesses. They have tried their best to hide their version, what they spoke before the police during the investigation. The truth has to be scanned. That doesn't mean
ସେଇଟା କ'ଣ consideration କୁ ଆସେ?
PW
6.
6.
She died in a matrimonial house. So section 106 of the evidence states that. I'll just place PW6.
Let us see PW 6 says.
Doctor.
Yes.
May I?
Read it.
On 11/8/1990, our surgery specialist attached to the government hospital worker. On that day, the police record. Before that, I just placed the defense grounded that she suffered from a epilepsy and she died. Now I place. On that day, the police requisition, along with Dr. Sahadev Sahu, conducted postmortem on the dead body of one Jenna, wife of village also, identified as also. I found following external injury on her body. Suprapubic evasion 3 into 3, left cheek 2 into 1, right cheek 2 into 1, right arm 4 into 3, right chest wall 6 into 4, extended up to right shoulder. All wounds are antemortem in nature, internal injury. Fracture of left pelvis with dislocation of sternoclavicular joint, dislocation of right shoulder joint of hemorrhage into joint cavity. Small intestine shows hemorrhage into walls of 5 places. Congestion of right lungs with collection of blood into pleural cavity. The death is due to hemorrhage and saw. Time since death is 36 to 48 hours. At the time of postmortem, the examination, it was time is 11/8/1990, 4 p.m. Injury in the suprapubic correspond to intestinal hemorrhage. External injury 6 correspond to the dislocation of right shoulder with the internal hemorrhage of joint cavity and hemorrhage to pleural cavity. Exhibit 6 as the postmortem report is a sonsolus. You should kindly see the cross-examination. All the
Not possible. Not possible. The fall of
It is
veranda.
not possible due to the fall from the veranda simultaneously. The swelling injuries and the external injuries which I found in the cheek and suprapubic region are possible due to fall. So also the other external injuries the external injuries which I found may cause hemorrhage. You should kindly look into the internal injuries that she had.
How the trial court deals with this part of it?
Yes.
And what is the 313?
ବାକ୍ତ ମାରୁଥିଲା ପଡିଗଲା ମରିଗଲା
Hmm?
ଷ୍ଟାଣ୍ଡ ଅଛି ବାକ୍ତ ମାରୁଥିଲା ଝିଅକୁ ପଡିଗଲା ମରିଗଲା
ପଚାରିବେ କଣ ଯେ ଏଥିରେ ଅଛି
Problem is so
Like,
many injuries.
she died within 7 years of marriage and having multiple fractures.
acoustic.
So
Let us see how the trial court deals with the PW6.
and see the 313 statement.
313.
313. Question number 4 is the relevant. Exhibit 3 shows that Lakshmi Jana died on an unnatural death on 10/8/1990. What do you have to say? Bhakta marriage. Bhakta marriage. That was a different statement.
313 guy. Postmortem. Home office. Fine. That's it. Only one accuser.
No, you have three accused. In the meanwhile, appeal number 3 has died. Father-in-law has died.
Then who remains?
Father-in-law
Who remains then?
brother-in-law and
ବିଜୁଳି ଜେନା ହଉଛି ତାର ଯା ତାର ବଡ ଭାଇର ୱାଇଫ accused number 2
ସୁରେଶ ଜେନାର husband.
wife my husband
no ବୃନ୍ଦାବନ ଜେନା son of ବୃନ୍ଦାବନ ସୁରେଶ ଜେନା son of ବୃନ୍ଦାବନ ଜେନା
husband dear.
ନକୁଳ ହେଲା କିଏ ନକୁଳଟା କିଏ ସାଙ୍ଗେ
Father-in-law
Evidence extra, na?
କପିଳ
Then your case is only 113. Evidence check. Presumption.
3B, 106 and doctor's evidence death in the matrimonial house within 7 years of marriage that
Now, where from you get that matrimonial house she died?
I'll so that is registered as a UD case.
498
I'll place the
goes.
UD case first.
498 goes. There is no 498. There is no nothing. But the 113, 304B will be IPC, then, 304B. How will you get out of 3? Okay.
and Suresh Jana is a different family altogether. Altogether a different family. Balaji.
No, kindly see exhibit 3 and the UD report in it.
Exhibit?
Exhibit 3 page 36 of the liquid. ମୁତଫି ମୋର ପୁତୁରା ବୋହୁ ରସି ଲଗାଇ ଆତ୍ମହତ୍ୟା କରିଅଛି ମୁତଫି କରିବାର କାରଣ ମୁଁ ଜାଣିପାରେ
1 minute. Let me see first the provision. 304B. कितना कुछ कर 304. Come to 304B, madam. 304B. Yes. Injuries are there, no problem. Injuries are serious. Unnatural death is there.
Yes, sir.
7 years marriage, no problem.
Yes, sir.
But the other ingredient which can't be believed,
Yes, sir.
soon before the death, it is shown that soon before her death, she was subjected to cruelty or harassment
Yes, sir.
by her husband or relative
Yes, sir.
of her husband for in connection with any demand of dowry.
Yes, sir.
Such death shall be called as dowry death. So how will you bring that part of the ingredient where there is soon before the death, there was harassment relatable to dowry because none of the family members have supported. If that ingredient, how will you satisfy?
Please, exhibit your.
Let us.
This type of.
If then that ingredient is not there, even if you, the natural death and injuries are serious,
302 would have been a better case.
302 would have been a far better case for you than 304B. You are right.
I'll just wait.
Let us see the element of soon before aspect of it. Let us see. Let us see who all are they.
I'll start with the.
Let us read all the evidence.
No question has been also put in that.
Let us read from one. One.
I'll start with the UD case report, which was lost by the.
I agree.
Yes.
It is unnatural death. Serious injuries are there. Everything. Now only thing is soon before the death, there was a harassment in connection with dowry. That element you bring.
Reread the.
Yes, I understand. You have a difficult case now.
I'll start with the PW1.
PW1, read PW. I know all the accused persons in the dog and
My deceased daughter.
deceased daughter. He is the father. His father. Father? Isn't it? Father of the deceased.
Mother.
Mother.
I know all the accused persons in the doc. My deceased daughter Lakshmi had married accused Suresh Anna about 1 years back in the month of Baisakha. One Indramani Das was the mediator for the marriage. Prior to the marriage, accused Nakula Jana had no demand for dowry.
No demand for
For dowry.
dowry.
My daughter Lakshmi was hell and hearty with her in-laws. I do not remember I lost any report before the police regarding the death of my daughter.
Yes.
The APB file 140.
Gone. ठीक है.
I was examined by the police also.
Yes. In examination, cross examination, have you got anything?
PW2 then. I know the accused person in the doc. PW1 is my wife and this is Lakshmi was my daughter. My daughter had married accused Suresh Anna 1.5 years back. There is no demand for a.
You're reading
gold-
what? Cross examination. PW2. Okay.
PW2
Who is he?
is the father.
Father. Okay. Yes.
I know the accused person in the doc. PW1 is my wife. The deceased Lakshmi was my daughter.
There was no demand of dowry.
There is no demand for a golden bangle from the side of the accused person. It is as if
My daughter was quite comfortable.
yes, comfortable and happy with her in-laws. Accused person, I cannot say how my daughter died.
No harassments.
Please, brother.
Now come to 3.
Worship, cross-examination of
Yes.
PW2 and continue. I was examined by the police. It is a fact that I've stated before the police that accused Nakula Jana, father-in-law of
That is what the trial court says. Before police he has said. That is
the
neither here nor
the
there.
golden bangle and a necklace prior to the marriage, which I could not give. It is not a fact, it's also.
No. Who is 3? My sister. Brother.
Yes.
Brother.
I know the accused person in the doc. My sister Lakshmi had married the accused.
There was no demand of dowry.
There is no demand of dowry from.
Was
the
quite
side of
happy.
the person.
Yes. And the rest of the thing I agree. Completely agree. You have made out that part of that portion, the ingredient you satisfied. The unnatural death within 7 years of marriage.
Yes, sir.
Serious injuries are there. Everything is there. But
Could have been a better case for 302 rather than a 302.
302. The second ingredient required for 304B,
Yes.
completely absent.
Connection is missing.
Completely absent. So they do.
all the interested witnesses are trial hostile.
They have a better management. They could
They could manage.
manage the industry. This is my father, mother, sister, everybody. They could
Even
manage.
the PW the father, he says there is no demand for Bengal gold bangles. As if someone is questioning what was the.
But the sentence they say, all of them say that she was comfortable.
She was comfortable.
Then soon before the death, harassment, where is that? Demand of dowry is not there. Soon before the this thing, nothing is there.
As per that, there is never any torture, irrespective of.
That's, then to the 304 we completely washed away. Okay. So, and the trial court is fundamental things also. 161 statement. But I have to convict somehow.
In a case, February 2025, SCC online Supreme Court judgment, where trial court has acquitted in a case of this type, but Honorable Court there, they convicted. Again, government appeal was allowed. Supreme Court said High Court should not have been swayed away. Well, let me see paragraph 46. Latest paragraph.
High Court took the reverse before. Huh? Yeah.
Paragraph 46 by the basis. We cannot but observe that the judgment of the High Court reversing the order of acquittal of the trial court proceeds on mere surmises and conjectures, relying wholly on the testimony of the investigating officers, who merely regurgitate the statements recorded under 161 and the voluntary statements of the accused. As has been rightly held, so and so and so, when the statements recorded under 161 of the Code of Criminal Procedure is resiled from, there arises a possibility that the police coerced such statement, but considering the huge prevalence of such instances as in the present case, the entire witnesses turning hostile, there could be various other factors also. Well, at paragraph 47, we quite understand the consternation of the London judges in the cold-blooded murder of a person carried out in front of his own son, where the investigation, though elaborate, it collapsed miserably at the trial, where the prosecution witnesses, all of them, turned hostile. We share the consideration of the London judges, but there is no reason for us to rely on section 161 of the 61 statements or the stories scripted by the investigating agency based on the so-called voluntary statements and the recoveries made, which the prosecution failed to prove to have a nexus with the crime. Like that, in paragraph 48, they are ultimately allowed the.
One of our former judges appeared in this matter.
Justice Sudhanshu Bhalia and Vinod Chan.
No, appearance.
Alright?
One of our former judges has appeared in this matter.
My lord, Honorable Justice Das.
Ratnagar Das. Completely, madam. Not.
Charge was framed under section 30. Only 304.
It could have been a case of 302. You could have been sustained that.
Charge was 498, 304B and 4D.
Yes. Thank you.
Item 6.
May I please your question?
So, yes, incomplete documents are there, merit. Even pages there or pages not there.
There are two appeals or what? Of February.
पूरा TCR টা আসছে কারণ আসেনি but the second page would have missing full so
Huh?
this was the second page of the
Or is he
the
directed
second
to
page was
ensure the
missing.
entire trial court record of sessions courts also in the court also for actually summoned in the present case by next date of hearing. Has it been done? Yeah. What is the there are see the notes. Note. Any attempt is made? Yes, he. Call him. Who is responsible? Call him. Who is? Huh? Superintendent. Both of them call it right now. मजाक बना रहे
Milo, one more submission may made.
We have seen it, but that particular page is
Yes, yes.
not there.
Every 2 months, odd even pages are not
Ah,
there. Odd.
Second page.
And Mal, this is a part file.
Hmm.
The main convicts are that Gokul Biswa and others had filed a appeal matter that has been disposed of. That record may be called for matter. Criminal appeal number 251 of 90.
251.
Of 90. It is
There are
there.
how many accusers were there?
In this case, only one matter.
And
Matter what happened in the FIR lodge against 4 persons.
they absconded.
Police filed false report. Thereafter, the learned magistrate took suo cognizance. And these petitioner came into light of in view of the 319 petition.
Okay. The main accused persons
They are other
they have been
trial and
convicted or acquitted?
convicted, and they had filed criminal appeal number 25190.
Mhm.
That has been disposed of on 25 cents.
Dispose of means the appeal is allowed or
Well,
because it is written here dispose of on 22/10/90. What is that? Criminal appeal 339/92. What is this?
Well,
Here it is written just
kindly have to answer the
in
page.
written, disposed of on 22/10/90. What is this? That appeal is disposed of when? The
25 cent 2007. My kind of glass to page 122. 122.
The impugned judgment.
Judgment, man.
disposed of on that.
That was
Okay.
it.
20.
1 page number 122.
122.
In that case, the record was called for and has been sent mirrored. It was disposed of by Honorable Justice Pradeep Mahathi in a Loko Adalat case. Loko Adalat, it is written by play 122.
122 कहाँ भाई 122 कहाँ दिख नहीं रहा 122
Towards last one after before the judgment portion.
before the
Judgment portion, Maharaj.
oh, 1 minute
I am reading it.
120 read it
I am
take it out 122 please 122
It is written from additional session judge Palla committee to the judge in charge Palla committee, Maharaj. I am to request you that the head comparing clerk may be directed to prepare and furnish the certified
Eh?
copies of
79 page 122 where you got it?
122 of TCR.
TCR 122 just see 122 assistance there is handwritten
Yes.
judge in charge of copying
Yes.
section yes I am to
The
request-
certified copies of the aforesaid documents may be prepared and supplied to this court by 5th November 1990. As the original case record in is session case number 2589 is to be submitted to the Honorable High Court for reference in criminal appeal number 221 of 90. That was in respect of Gokul Biswa. Sit again, bahar kotele. Case status
that is number criminal appeal
251
number
of 90.
251 of 90
It can be found out from the case status, ma'am.
251 of 90
Dispose of it and maybe TCR ta फेरी भी जाई थो.
no, what he says that the original record may be there
No, may not be there in 2007 that the connected appeal has been disposed of since 2007.
Yeah.
The chances that के ना पुणे remit back ही जाई थो TCR टा. Maybe तासे तो असली जाना पड़ी
And I found this that was disposed of 25/7/2007. It was written Loko Adalat.
original record case is so is to be submitted.
It's nine.
But you call for the record because see the original it says that the entire original record in the SC case number 2589 is to be submitted in that appeal. This is 2589. Call for that. Call for the record of criminal appeal number 251 of 90. 251 of 90. Let them come. We'll see.
and
Call for the report. Okay.
लास्ट ऑक्यूजन से ट्रायल कोर्ट को भी डायरेक्शन दिला TCR दवा पे.
Yes, I am calling them. They have not read the proceeding also.
Yes.
This section officer and all. You call them. Call them. See, these matters, everybody is taking casual this thing, nothing will happen. And this casual approach since last 30 years.
Communicated to the.
So the
Right.
section
The-
people are also thinking the old matter, let it be like that. Huh? No, no, let him come. Let to be in the board, it will be there. We call for them. Next week we'll take it up. Yes.
Item 7.
Yes, more popular. Om Sarma. Om Sarma.
Then maybe pass over it
Huh?
of senior Vigyan Sharma's case.
This one.
Yes, yes. And this report is there.
Okay. Pass over, let us see. Pass over. 8.
Item 8.
Hmm?
It should kindly be taken up at 2 p.m. along with the item 3. And senior will appear. Item 3.
Mr. Raghuda was
Mr. Ragada, acha, he said, yes, he told. Mr. Ragada.
Item 9.
Item 7, my lords, I may be pardoned, my lords. I'm on my legs, my lords. Can it be taken up on Thursday? My lords, can it be taken up on Thursday? I'm on my legs, my lords.
No, it will remain like this only. You come whenever you go.
My lords, my lords, my lords.
Yes.
Item 9.
If 10 years of conviction is under section 304, your lords.
Only appellate number 2 has died. Appellate number 1 is there. Sahu. लेना फाइल देखते मिस्टर साहू इसको कॉज लिस्ट में थोड़ा हाईलाइट करो यार नॉट टू बी अर्जेंट इतना छोटा सा लिखिए राइट व्हाई डोंट यू हाईलाइट इट अच्छा नहीं इट्स देयर बट हाईलाइट इट बोल्ड को लिखना चाहिए यस sentence is 2 years 2 no, fine 10 months
No, 10 years, your lords.
10 months because
Page 50, your lords. Page 50.
arrive for 10 months and to pay fine of rupees 500. Sentence
10 years.
10 years.
10.
April with 10 months. के करेगा.
Page 43 bottom.
That is
43 of the judgment.
10 years.
Your lordship.
Sentence to undergo arrive for 10 years.
Yeah. Vinod is there for sentence to undergo 10 years for the
304.
offense of 30 304 IPC and convict
For 10 months for offense under 342.
Guna tara ganta
Ah,
it was expired also so seita to
One died, huh?
yes sir
No, 2 died. One is there.
yes sir Vinod is there
Both of them are convicted.
Both of them are
Convicting the appellant Vinod Ganta for 304. Consider. Vinod Ganta, one is convicted for
10 years
10 years and the other one is
10 months
10 months. He died.
yes sir
Then Vinod Ganta is the main. Let us see. What are the
4 eyewitnesses,
Hmm.
CW 2, 3, 4, and 12. CW 10 is the doctor. CW 10.
Nineteen.
CW
Schedule
4.
schedule 10.
Yes.
Schedule 10 is the doctor errors.
Hmm.
Schedule
Schedule?
10 is the doctor. Page 110.
Okay.
Of the paper.
Let's see, schedule 10.
Paper.
Hmm.
Yes, sir. May I please?
CW 10 is not here.
110.
The paper book.
Huh?
Paper book.
Paperwork only.
Yes.
110. Page number 110.
Page number
110 euros.
110.
Again.
Soft copy of the paper book is also available.
Acha, ulta sidha hoche, 110.
Again.
Okay, yes. CW 10 doctor.
On 2192, I was medical officer in the headquarters hospital, Balishwar. Say to sir,
They conducted postmortem examination along with
on external examination, the dead body
So, the dead body.
I found as follows.
Girish Chandra Mehta.
And point number 2, on dissection of the dead body, dissection of the dead body, I found the following. Lungs were normal, liver were also normal, stomach. 3.
Which-
On
which-
dissection of the head injury as mentioned above, I found one linear fracture having length of 5 cm. The injury in the left partial bone resulting in the substantial more marked on the left side and causing compression of vital organs like brain. The injury was an antimony in nature.
Compression to the vital organ, link brain,
Vital like brain. You know.
like brain.
Yes, sir. The injury is antimony in nature. The duration of the injury might be within 36 hours by the time of my examination. The cause of death was due to the hemorrhage and shock following injury to the vital organ like brain. The
With the eyewitness, PW
4 and 12.
3, 4, and 12. Huh?
2, 3, 4, and 12.
Let's see. 12 I'm reading.
Start with CW 2.
3, PW 2. Page?
Page 80 of the 50.
80.
Yes.
May I please?
Hmm.
I know that this is Girish Makov and both the accused person on the drug. I know the informant. Very good. My house is situated at a distance of 30 to 40 cubots apart from the house of deceased of Girish Makov and at a distance of 50 to 60 cubots apart from the house of the accused person. At the time of occurrence, I was brushing my teeth, sitting on the outer veranda of the house. At the time, a holla was heard from the body of deceased. This Girish adjoining to the body of the accused person. The place where the holla was heard was visible to the place where I sat. In course of quarrel between Girish and accused Gunadhar, the latter came and caught hold of the former accused Gunadhar, called his
his-
son, accused Binod, who was 10 years of age.
Do away the life of the
To the
deceased.
eye of the life of the deceased. At this accused Binod rushed to the spot, being armed with a bamboo lathi. and asked his father, accused Vinod, to leave the deceased so that he would kill him. Saying so, accused Vinod dealt a lathi blow to the left side head of the deceased.
Head injury.
Head.
That corresponds.
Yes, the doctor also. As a result of which the deceased sustained severe bleeding injury on his head. Then accused
Another left.
the expired accused, applicant number 2, left the deceased and went away. Then I came to the spot prior to my arrival near the spot. Montu Makeup and his sister Puspa had already arrived there. After my arrival, Bhaskar Makeup and Basant Makeup came to the spot. When Montu Makeup came to the rescue of his father and tried to lift him, accused Vinod dealt 2 lathi blows on his left side shoulder.
Accused Vinod left to Montu. When the Montu Makeup came to
the rescue of his father. Montu Makeup.
And he has given a blow. Huh?
Yes, Lord.
Montu Makeup is PW.
Montu
Must be injured with PW.
It will be 12.
12, huh?
Yes.
Okay. Yes. Yes. When I, along with so got the accused person, went away.
In para 4 here also, this is the bamboo lathi which was used by accused Vinod in assaulting the deceased. It is marked as MO1. MO2 is the napkin, kurta gamcha used by the deceased at the time of, because MO3 is the lungi on which wound of the deceased wrapped. MO4 is the torn banyan worn by the deceased at the
Torn banyan and in the cross, let us see what
Yes, yes.
Lathi was recovered, huh?
Yes, yes. MO1. Yes. Bamboo lathi like MO1 available in the house of the other villagers. I saw MO1 at the time of occurrence and thereafter now in the court. MO has not. Process किसी नहीं था. In cross examination, page 83, para 9 also, accused Vinod was standing in this barry when accused another caught hold of the deceased Girish. Accused is caught hold of the deceased from his right side. Because se Girish ଧରି ଥିଲା ଆଉ ବିନୋଦ ତାକୁ ମାରିଥିଲା ସେଥିରେ ଆଉ.
Let us see 12, huh? Come to 12.
2, 3, 4. PW 3, 4 would be also relevant.
No, he also, whether he says that he has received any injury. He is another son of
Deceased.
brother of he is son of brother of deceased.
So at that moment, I will.
His son, he is another son.
Is another son. May I please see relevant? At that time, my father was returning after birth, and while he was drying clothes, the wife of accused Vinod Renuka was found driving a bullock from her body to her body. That bullock damaged a banana tree of her body. My father asked me to drive away that bullock from our body. When I did not listen to him, he got annoyed with me and he himself proceeded towards the bullock to drive out it from our body. When my father chased that bullock, it went inside the body of the accused. Then Renuka, the wife of Vinod, raised halla. Hearing the halla, her father-in-law Gunadhara came and picked up quarrel with my father. In course of quarrel, Gunadhara came inside our body and caught hold of my father near the banana tree and asked his son, accused Vinod, saying, Vinod Dodia aku khatam kari de. At this, aku khatam kari de. Eha ko khatam kari de. At this, accused Vinod came running to the spot, being armed with a bamboo lathi, and asked his father, saying, "Bapa chhada taku muh khatam kar diye." Seeing the accused, Vinod came running to my father, being armed with lathi, and requesting his father to leave the disease so that he could kill him. I started running towards the spot to rescue my father, the deceased.
Like he says, hurriedly I rushed to the spot and tried to lift my father from the ground. At that moment,
Yes.
accused Vinod dealt
Dealt
two
a
lucky blows,
to my left shoulder.
left
As a
shoulder,
result,
and
I
as a
sustained
result, I sustained killing injury. That part is also.
That is intact.
And you said two, na?
That's
Three.
please
Two.
well.
All of them are consistent.
Yes,
Yes, Your Lordship.
Let us read three.
That bamboo lathi has also been seized and that is marked as MO1.
M1, that's right.
Hmm.
Okay, let us see three now.
Yes, sir.
Second para.
To Your Lordship. Page 86. While I was in my threshing floor, a holla was heard from southern direction. Hearing holla, I came to the boundary line in my threshing floor and saw the accused persons and the deceased were quarreling between themselves. In course of quarrel, accused Gunadhar came to the deceased from his body and caught hold the deceased from his right side. Even he said that applicant number 2 was caught hold. Then accused Gunadhar called his son, accused Vinod, saying, Eko khatam kar de. At that time, accused Vinod was present nearby and called his father, rushed to the spot being armed with bamboo lathi and told his father to leave the deceased do away with his life.
To do away with his life.
Saying so,
the
accused
accused
Vinod
Vinod
forcibly
was-
dealt a lathi blow on the left side of the head of the
Left
deceased.
side
guest.
head of the same
Yes.
head injury,
Yes, Lord.
which doctor says.
Yes, sir. At that moment, I left the deceased who fell down on the ground. The informant and his sister Puspa were in the thrashing floor at the time. When they saw the incident, and
He also supports.
yes, sir.
PW too much.
Even the second line, you say the informant tried to lift his father from the ground, and at the moment, Bino dealt lathi blow on the shoulder of the Montu.
PW12 was examined by the doctor. PW12, not examined. Swelling injury. And similar is the version of PW4 also. PW4, para 2, main between next, 93, page 93.
Yes, sir. Period 4.
Being called by the wife of the Vinod, both the accused persons rushed to the spot, being armed with lathi and
Being called by the wife of the Vinod, both the accused
Gunadhar
person.
told Vinod saying, same story.
Same story. Accused Gunadhar told Bino saying,
My brother was.
my brother was supposed to sing. Same thing, so said, pura separate.
assault to the deceased and assault to the PW.
In the cross also nothing could be.
In pre-emptory statement, Your Lordship.
Pace. Yes.
66.
66, yes?
866, question number 47. That is the plea of the defense.
66.
66, page 66. 66 of the paper.
No, 66 is something. No. 66 one.
The
66,
previous
yes.
anonymity
Yes.
is also admitted by the accused person. Now may I read? What more you have got to say regarding this? Mutafa, Kadali, ଜମି ଆଗ ଆଡକୁ ଲାଗିଛି ସେଥିପାଇଁ ଆମର ତାଙ୍କ ସହିତ ବାଦ ବିବାଦ ଲାଗିଅଛି ମୁତଫା ତାଙ୍କ ବାଡ଼ିରୁ ମୋର ଗୋରୁ ଖଉଡ଼ ଆଣୁଥିଲା ମୋ ସ୍ତ୍ରୀ ରେଣୁକାକୁ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳି କଲେ ସେ
rather it is
fell down and sustained injuries and he died. The entire
Admitted about that.
the previous anonymity was there.
that part is admitted.
That part is admitted.
Admitted about the regarding the quarrel on the same day. Or
That is also admitted. Presence is admitted.
Yes, sir.
That's much more dangerous.
Yes.
What is that? Let's see, initially it was 302, it seems.
Yes, sir. Lordship.
So he might have been taken into custody. Let us see how much he has undergone.
Okay.
10 years sentence, maximum sentence given. Let us see. During trial, they were in bail.
By the time it was committed to the court of session, he was already on bail.
In 21/1/92,
They have been arrested.
they have been arrested also. 21/1/92.
21.
190.
Arrested.
What is it?
Hmm.
What is it?
Yes, yes, yes.
Comments.
ଚାର୍ଜସିଟ୍ କମିଟେଡ୍ ହେଲା ସେ ଅଲରେଡି ବେଲ୍ରେ ପଳେଇଲାଣି 21/10/92 ଚାର୍ଜସିଟ୍ କମିଟେଡ୍ ହେଲା ସେ ଅଲରେଡି ବେଲ୍ରେ ଗଲାଣି।
No, just see the proceedings are there at the end of the record, last TCR, just see. Here, producing jail custody record put up to file advocate accused person advance copy files. Original report received. If proceeding, if you see, then proceeding you would get it. April 1992, they got the bail. High Court granted them bail on 6/3/1992. 6/3/92. High Court bail granted. Arrested. And bail bond given on 3/4/92. Okay, I got it. Proceeding dated 3/4/92. Just see. 3/4/92. I told you in all the matters you find out. This is very important. 3/4/92. The records are put up today on the memo filed by the advocate for the accused persons. The advocate also filed certified copy of the order dated 6/3/1992, passed by the Honorable High Court in Miss case number so and so, allowing both the accused persons, Vinod and Gangadhar Naik, to be released on bail. Okay, thereafter the bail bond is furnished. So thereafter he was arrested again when the judgment was passed. When the
Judgment was on 3rd February 1994.
3rd
February 1994.
94 judgment, huh?
Yes, sir. It's, High Court got bail 8 March 1994.
Date
8 March, 8/3/1994.
8/3/94.
1994.
Then bail. Then just see then 21/192 to 30th April 1992. Then it will
3/2/94 massive 1 month 5 days.
February, huh?
What?
21/192 to 30th April 92. Kete lago?
It is 3 months, 3 months, 9 days.
3
Plus
months.
9 days. April 1 month, 5
Yes.
days.
Yeah, 1 month,
5 days. 4 months, 14 days.
5 days. So 4 months,
14
total?
days.
4 months, 14 days. Undergone period. This is the undergone period. Sentence is 10 years.
10 years, yes, sir.
Yes, it'll be part 1 only,
Again.
not in part 2.
Can you-
304 part 1. 304 part 1. 304 part 1, maybe.
Again, 10304.
Just check it up what display Rochito. Continue the display. He may come because it is conviction has to be upheld. Now it is only the question of sentence. Already undergone also we can't do because it's a 10-year sentence.
Nobody is appearing for the appellate. There are some defense witnesses they have examined. There are some defense witnesses they have examined. If nobody is appearing, we'll place that. If it can help.
I'll continue hearing. Continue. Defense, we will read it. Do you think that anybody will come and assess the same thing? See, everything has to be done by us. Don't expect any assistance. 90s, nobody is coming to, we can't.
That's one. The responsibility becomes double since nobody is appearing.
That's right.
There are some defense witnesses have been examined.
We will read it out, what to do. We will read it out, find out.
Yes.
Find out. Nothing can be done, See, if they don't turn up, 10-year sentence. 10-year sentence, they should be little, just read it. That part also we'll read. But now it is clear that he has already undergone about 4 months. 4 months, 14 days. So I was thinking loud, even if you reduce down to 50%, it will be 5 years. 5-year sentence. It can't be lesser than that. We can say
Yes, yes.
it can't be lesser than that. Because evidence, all other eyewitnesses, everything supports, finds corroboration, recovery is there,
Yes, sir.
recovery is there, and the 313 statement is worse. That proves that they were present.
There was solemnity and.
And the only defense is the injury caused because of he fell down or something. The doctor doesn't say that.
Yes, sir.
There's no
Head injury.
particular- There's no particular suggestion to that.
Suggestion also, nothing is there. I don't see. We'll see defense evidence what exactly. Defense must be regarding the same past enmity. Past enmity is double-edged weapon.
Segregation. One says the accused persons are not there, the plea of alibi is there. And secondly, he is accidentally failed down. And Renuka, there was a clash between the Renuka, the wife of one of the accused, as well as the deceased. There are 3 types.
That no. Then no. It is neither here nor there. Their presence is proved then. We'll see.
month. And my lord, I am not praying for taking today, my lord. It will be since
The report has come.
ସେଇଟା ପାଇଁ ଖାଲି ଟିକେ ଲାଷ୍ଟ ଅର୍ଡର ମିଳର 6-11 ଟା
Yes, I know, remember.
ସେଟା ସେଇଦିନ ଗୁରୁବାର ନିଆଯାଉ ଆଜ୍ଞା ଅର୍ଡର
Thursday I'll take it, but to get the report,
ଆଜ୍ଞା ସେଇ କଥା
because see, co-accused has been granted interim bail on the basis of some report. See, same report I want.
The matter has been interested, I assigned to Mr. Ashok Kumar Rathod. So.
Thursday,
I-
Thursday.
ଆଜ୍ଞା ଫାର୍ଷ୍ଟ ଡେ ପାଇଁ
Pardon to make a mention, Lordship. Lordship, item 44, Lordship. We have filed an additional argument note and memo of citation, Lordship.
44.
Item 40.
Whenever I'll hear, I'll take it up. Take it up. Yes, yes, Mr.
Item 9.
9.
Item 9.
Oh, that the one which I was hearing. This matter also, Mr. Raghuda, since you are doing it, here the 9, na?
9.
9, partly I heard it, but this is very difficult case. 10-year sentence. Nobody is appearing. And the Vakalatnama, I saw that the judges and few judges have retired also. They are Vakalatnama.
Earlier also I appeared in one case that is there.
The same thing, same problem. And I have heard it. Thursday, because 10-year sentence.
It's already been prepared, so.
Huh?
Paperbook
Paperbook
shall
prepared, you give the
be
paper.
done.
Give the paperwork, no problem. I have read it. The problem is 10-year sentence. We have, with the help of them, we have gone through. It's a case of conviction. But sentence, we have seen 4 months, 14 days undergone. So just see if anything can be found. Otherwise, what to do? Otherwise, we have to either reduce sentence to 50% or what to do. Paperwork. Give the paperwork to him Thursday. Take the paperwork. Thursday. Yes.
In all cases I am taking paperwork and after.
You
and
give
I
it
will
back.
never
It is
return back.
so that.
Doing balance.
Yes. No. Was he partly part heard? Heard Mr. Part okay. Yes. Appointment for okay. Yes.
So item 3.
3. Yes.
That's matter gone through the only judgment matter, not going to the evidence part matter. But in fact matter, there are 3 accused persons matter. They face the trial. And all of them matter convicted at 304, charge frame 302, 34. They convicted also 304, 34. And they have filed 2 separate matter criminal appeal before this court. The other co-appeal persons matter, they prefer criminal appeal number 107 of 91. And a report call for they have expired abated.
Now this appeal only remains.
Only this appeal matter.
Money 9.
Money 9. Money matter super money is concerned matter. Initially case.
You give me the. I'll refer it again. Okay, no problem. उनके पास रहेंगे. मैं इसमें रेफर करूँ. ठीक है.
The super money is concerned matter. The alleged occurrence having taken place on 22/10/88 month. Date of occurrence
14 to
22 22/10/88 at about 9 p.m. And FIR lodged on 22/10/88 at 10:30 p.m. But case registered on same day 23rd/10/88 madam.
registered on, reported on
Same day madam.
same day, but registered on 23.
राति 12 पर है तो नहीं तो
ठीक है.
10:30 ठीक है. And then received by the magistrate my lord on the next day, very next day, that is correct madam, 24/10/88. Madam. As for the FIR my lord, there are my lord all total my lord Schedule 1, Schedule 6, Schedule 7, 8, 9, 10 are the eyewitness occurrence.
Schedule 1,
6, 7, 8, 9, 10. Though Schedule 1 is the one of the eyewitness my lord, he became hostile, declared hostile. Schedule 11.
1 hostile.
Schedule 11. 1 hostile. Schedule 11.
11 hostile.
Hostile. And P-double 1, my lord, he also injured and a eyewitness to occurrence and a lodge the affair, informant. P-double 6, another injured eyewitness.
Yes.
My lord. The case prosecution like this, my lord, it is alleged that one Lakshmi Naik, my lord, he attacked by the evil man, spirit. Her husband taken to the temple. There the priest was, the lady priest was there, and some these witnesses they are performing puja. Someone beating drums and some others, other utensils, my lord. By the time this petitioner, 3 accused persons, those are dead one, 2 persons, they appear there. They stated to the priest and other witnesses who are present there that you all have taken liquor and beefs for that in the Thakur Asana there will. Thereafter there is quarrel between the deceased and the
People, yes.
that matter has been specified. That is decided. And again, my lord, it is alleged that the deceased came with an iron rod. And some person, people, element stated that is probar, sabara, probar. Thereafter, there is a quarrel between them. And those 2 accused persons are expired one in the meantime. They cut hold of the deceased, and this petitioner, this appellant, pierced a bhala, pointed a weapon on the belly of the deceased. One blow, single blow. Thereafter, 307 case under section 307 are instituted against all 3 accused persons. This is taken to Dhekana headquarters hospital. Thereafter, taken to SC medical and died after 22 days of the incident.
Died on?
Died on, my lord. 22, 10, 9. 16, 11, 28.
Yes.
After 22 days.
22 days.
And P-double 4,
Any statement or any dying declaration?
no dying
is
recorded, and no weapon offense were seized recovered, my lord. Only MO1 lungi. Other weapon offense that has not been recovered, my lord. And no weapon offense and no dying declaration. My lord, the P-double 4, my lord, the doctor who conducted post-mortem.
Let us see.
PM.
Yes. Let us see.
None of the paperwork, my lord, paper in that earlier case, my lord, that must be available. I am holding that. The co-accused persons were separated.
Paperwork. Is not there. Yes. Give the other 104.
I am holding.
100. No, yes, I got it. I got it. Yes. That is Navakishore Samanto.
My lord.
Navakishore Samanto.
PW4.
4, madam.
Yes, PW4.
There are 3
No, no.
doctors. 3
PW
4.
Acha, 4. KC Biswal.
My lord.
What does he say?
P-double 4, madam. On 780, I was the assistant surgeon of the district headquarters hospital, Dhekara. On that day at about 12:10 p.m., I conducted a postmortem examination on the dead body of Ajay Naik, son of Nalu Naik of Dandasai, Jubul town, Dhekara. The dead body was identified by me, Constable Sachan Bala, and a relative Akhay Naik and Amulya Naik. The constable made over me to the inquest report, dead body chalan, in respect of the deceased Ajay Naik and the command certificate.
Let us see the injuries are. One injury.
Injury are page 52. One stitch of 1/2 inch length seen over the right arm, over the elbow joint. One open on 5 semi in length of abdomen through which internal
Abdominal injury is there.
that is mallet. Stitch mark also seen in some places. One drain wound on left iliac fossa on dissection I found following. Evident of the old injury of
The mid portion of
the
jejunal
was
wall
with dark and
and dark red
irregular
patches
seen in the jejunum.
and
This
this
injury corresponding to external injury number 2. All the injuries are antibiotic nature. Injury number 2, abdominal injury. 2 cause
and then the injury number 2 is in
murder.
old injury.
Old injury.
Mm.
Injury number 2 causing injury to the small intestine can be ordinarily course of nature, cause death of a man. The cause of death is due to fascial peritoneum leading to septicemia, which death was within 24 hours of the time of postmortem examination. I cannot say if the injuries on the disease could be caused by bhala. That is very important, my lord. I cannot say if the injuries on the disease could be caused by bhala, exudate, and bhala. Exudate is the postmortem examination report. Documents of the wearing apparel of the deceased were returned to the constable. That is, my lord, the most important, my lord, all the eyewitness 1 to 10, my lord. 1, 6, 7, 8, 10. Though
9, 10.
11 declare hostile, my lord. They have categorically stated that this appellant asserted by means bhala to the belly of the deceased. But here, my lord, doctor stated that I cannot say the injuries on the deceased could be caused by bhala. I have not mentioned in the
But he doesn't say that it is not done by Vela. He says that I could not.
possible.
Possible.
Why, my lord, I pointing that, my lord? P2 11, who was declared hostile, he, my lord, came with another story, my lord. He stated that the deceased came with an crowbar, pointed weapon, my lord, sabala. And while tussling between themselves, my lord, might be caused. Injury, my lord, causes, my lord. But that is I have pointed out this one. I have not mentioned the injury that injury number 2 can cause death in ordinary person research. But this is very important, my lord. He has not mentioned in the postmortem report that the injury number 2, my lord, which on the belly of the deceased, my lord, can cause death in ordinary person research. I have also not mentioned in exhibit 8 whether the injuries are antemortem or postmortem nature. I cannot say age of the injuries as per exhibit 8 due to infection in the internal injury of
He is the doctor who has conducted the
PA.
postmortem.
my madam.
There are 2
Postmortem.
doctors involved. PW3, 4
What,
and 14.
what PW3 says?
3
PW3,
the
PW3, my
person
lord.
who conducted surgery on the person of the deceased.
I am going
See that.
Madam. Pilot 3. On 22/10/88, I was a surgery specialist attached to the Dhenkanad Headquarters Hospital, Dhenkanad. On that day, I admitted injured Ajay Naik, son of Nalu Naik of Jubil Town, Dhenkanad, as an indoor patient in a surgical ward as per the bedhead ticket number such and such. The case was admitted with the stab injury on the left side of the abdomen, which needs
There is an abdominal injury.
There is admittedly abdominal injury, madam.
And it has gone through and through.
Madam. That is true, madam.
Mm.
But in fact, what happened, madam, the PW, if the PW 11 go declare hostile, madam, always the hostile witness, madam, double-edged weapon, madam. Some 50% towards the prosecution and 50% to the defense, madam. And
But 1, 2, 3, 4, 5, 6 witnesses have gone.
they have the supported prosecution, and most of them.
Those 6 eyewitnesses coupled with the doctor's evidence is enough.
Man, that is true. But in fact, what happened in this case, my lord, even if my lord consider the sake of argument, my lord, though this appellant, my lord, along with the 2 of the co-accused persons, they could-hold to the deceased and this petitioner, my lord, assaulted to the belly of the deceased, my lord. In fact, my lord, the witnesses, those are present there, my lord, they are the interested witnesses, my lord. Some of the petitioner, PW 1 is the brother of the deceased, my lord. All of them are relative of the deceased, my lord. They are interested.
You tell me who are his brother. Okay, PW1 is brother. The next.
Others, my lord, also.
6.
They are my lord, relative of the deceased, my lord.
Say injured witness.
Injured witness, my lord.
6 is injured.
Injured witness, my lord. That injury, my lord, is sustained. That injury gave by another person who has been not the victim. Only against the appellant, only he gave 1 blow on the belly of the deceased, not to the injured witness.
Therefore 304.
304, my lord. But in fact, my lord, 304.
But this is a case of homicidal death. There is no doubt about it.
My lord, the doctor has not stated in his whether it is homicidal or accidental or suicide.
Might not have said, but
that is lacking on the part of the IO also, the doctor, my lord. And
is it a case that it is an accidental one?
My lord, even if, my lord, the proper.
Have you taken the stand? It is an accidental death. Then have you put the question?
Only question is, my lord. After he preferred the appeal, my lord, he remained behind the bar for a period of Judgment my lord 28/4/1991
28
20/4/91
हाँ
କଷ୍ଟଡି ଥିଲେ ସିଏ
हाँ
17/5/91 ବେଲ୍ ଗଲେ
17/5/11 bail
ଆସିବେ ହଉ 20 near about 27 my lord.
hmm?
But in fact my lord, during course of trial my lord, investigation stage, I have not found the TCR not available. How much he remained in custody, that is not
Just see why not they, you can get
that is not there my lord. TCR not there. I have searched my lord in the
just see the charge sheet
my lord.
when they were arrested. Let us see.
TCR is not
Find out
there.
the charge sheet.
TCR not there my lord. It is not available my lord.
1 minute.
I think
TCR
ସେ
is
କେସ୍ ଡାଟା ଥିବ 107 ଏବଂ 91 107 ମାଇଲ
huh?
107 ଅଛି TCR ରେ କେତେ ଦିନ ରହିଥିଲେ ଜାଣିଥିଲେ ସେ 20 ଦିନ ସେଟା କେତେ ଦିନ ସେ ଏତିକି ଯାହା ପଡିଲା ଆଉ କିଛି ନାହିଁ
The sentence is
5 years.
5.
just see
If proper treatment would have been given my lord, this is can be survived my lord, but here is the case my lord, proper given 22 days long 22 days my lord has been operated my lord, and
he was money was 23 years
now
91
50
hmm.
57
50 maybe
91 रे
57 के आसपास
57
yes madam got it
Yes.
just see check it up
So please, there are two accounts.
the period custody period
Whether
custody just see find out
that's may
এটা
not
ଖାଲି
be
ଦେଖିବାକୁ-
relevant. I'll just please.
TCR ଟା ନାହିଁ ବୋଲି ପାଇପାରୁନି ଏ ଜଜମେଣ୍ଟ ପାଇଲେ
just check it up from there.
ଦେଖେ
नहीं किसी
କମ୍ପ୍ୟୁଟର
नहीं just see the IO's evidence
ମାନେ
he might have said
I would do 13
hmm.
On 20.
Who is PW 14
But it is the doctor of SC. Where he died.
yes.
There are 4 doctors. PW,
PW,
PW3,
PW 3 4 and 12
ମାନେ
14.
14
Sir, PW2. Just to show that the injury caused is sufficient in the course of nature to cause it. So irrespective whether he could have survived after giving the proper treatment, it doesn't arise at all, as inscribed in section 3.
yes, yes.
PW2 for a moment. On 2010, I was assistant surgeon at Headquarter Hospital. I have been examined one galvanic. He is the PW6 also. These are the injuries found on the person of the PW6 with the injured eyewitness. Thereafter, PW3, who first treated the district jailer. I'll start from the operating person. He was admitted 9:45 p.m. He was operated at 11 p.m. The following is the finding of the operation. There is a through and through rent, incised wound of half-inch.
Where are you reading?
PW3.
That I read. PW2 I'm reading.
PW2 is vis-a-vis the PW6 examination, who is the eyewitness come injured.
He has examined PW6.
6.
PW2, doctor, examine 6, huh?
6.
PW2.
And the paragraph 2 of PW2, he examined.
All simple injuries and all. Okay, so.
He examined both of the persons. One is PW6 with the injured, and paragraph 2 he examined the deceased.
One incised wound on the left.
One incised stab wound in the left.
Hypochondrium placed.
Hypochondrium placed
Obliquely
obscurely also,
which,
just over the physical, and may be inflicted by a sharp cutting weapon, which can also be caused by a bhala. Lordship,
I got it.
he is the first doctor before surgery who opined that the injury could have been meted out by a bhala. Thereafter, the PW3 who conducted the surgery, and the opinion about the surgery has been quoted here also. I'll just repeat that. There was a through and through rent inside window car.
That I read.
Yes, sir.
That I read.
In the middle of also. And he says, since the condition becomes serious after a couple of days, when 2 bottles of blood transfused and the patient showed sign of deterioration in general health by the end of the week, and he did not improve after all known measures taken on him, the patient was referred to SCB Medical College Hospital on 29/10/1988 for better treatment, and this is, of course, at the request of the patient attendant for the better management of the case. So, giving proper treatment order doesn't arise at all. The bed ticket is maintenance also. Paragraph 3. IO made a query to me to opine about the nature of the injury of the injured. I opined that the injury was grievous, and the query is marked as Exhibit 7. In paragraph 4, he said that I transferred him to the ACB Medical College. There is every chance of survival of the injured in such injury if better treatment is given. I have taken the consent of the sponsor. This is how. On 29/10.
14 is that medical college. Sir.
Medical college. On 29/10/1988, I was working as a resident surgeon at SCB Medical College, Cuttack in General Surgery Department. On that day, one Arjuna Naik, aged so-and-so, was admitted in the casualty department and subsequently an extra surgical ward unit 3 of the General Surgery Department at about 50 p.m.
No, sir, nothing can be done, Mr. Ravana. Nothing can be done. Because the one which you have shown me, that will not help you because the PW3, PW2, I said that is caused by Valla.
That is one of the concerns. Other eyewitness also settled so.
Eyewitnesses are there.
There are 5 eyewitnesses.
There are 2 IOs, madam. We told 12, only submitted charge sheet, madam. We told 13 is the preliminary IO, who stated in the evidence that he has arrested the accused on 26/10/98.
26/10/88.
Well, charge sheet of the accused is
26 arrested. When he got bail?
charge sheet of the charge sheet of the lower court charge sheet of charge sheet.
And also, there are a number of eyewitnesses who say the particular role played by this person, and because of the assault made by this accused person, the deceased died.
Died after 22 days, madam.
Might be.
That part may
Might
take concession, but in fact, madam, the Bhala in Cochin, madam, that has not been his laches on the part of the malada IO, madam. And he has not prayed for the recording of dying declaration, madam.
That can't be can't be a reason for not believing the eyewitnesses.
There are lacunas, my lord.
Lacunas
He
are
has
there.
not seized, my lord, the weapon offense. My lord, not that has been produced, and also, my lord,
It could have been done better,
my lord.
but doesn't mean that.
Hala and everything. They came up to the deceased. Thereafter, the assault was made and deceased died. So we cannot say even that it is sudden fight or even the conviction at 304 is unsustainable. I feel such case of 302. Since eyewitnesses are there and they say that after 4-5 hours before there was an altercation for which the assault was made. Can I place 2-3 eyewitnesses?
No. Then what do you say? He should be happy for 3024.
May not be a case for acquittal.
It's not a case for acquittal. I know that. I am just wondering how the balancing sentence has to be balanced. Sentence, just she tell me.
Charge sheet is not valid, available.
Charge sheet is there?
Charge
Sheet is not there. Charge sheet is charge.
accused column thibo kebate bail arrested nita record 26/10/88 nita statement is not.
PCR ଟା ବୋଧେ ଆର ରେକର୍ଡରେ ରହିଯାଇଛି ସେଥିପାଇଁ
ଆର ପେପର ଗୋଟେ ପେପର ହେଇଛି.
The biggest problem is I have seen in these appeals, very surprisingly, in bail application, nobody writes when he was taken into custody. Nobody writes. This is the very minimum thing. In appeal, when you move on a bail application, during trial I was arrested and such and such. They granted bail and such.
Only
Nothing is written.
only mention that from the date of arrest.
Later. What kind of drafting I just fail to understand.
Accused in custody from the date of arrest.
I have not found in one case.
they only say in custody. When
What is the meaning of that? Unless you, in a appeal, at least this is, this, it is
It will
bound.
help now, my lord, the time of a hearing. If that has been mentioned earlier, my lord, date of arrest.
Nowadays, it is good, at least in the judgment, the trial court writes, when you are taken into custody,
Custody file.
that is, because lawyers are not writing, therefore, the system is developed.
My lord.
But it is, if it is not written, generally, those applications are not to be entity. At least you should write.
Evidence, my lord.
Why should we struggle to get from the record period undergone? At least you should tell what is the period undergone. So there is no way of getting period undergone.
TCR is not the difficulty.
Period, my lord. One thing, my lord, if the report may be called for from the superintendent Deccan jail, for that.
Mr. Arora, if you start doing this, then another
expect
10
that
years
as-
it will take. Another 10 years it will take. It's a conviction case.
Release के बेला से बड़ी पड़ी।
Bail bond is there. Just see bail bond.
Bail note is not there.
Bail bond is there.
ना TCR थाले सब था अंदर TCR तो नहीं
Danda side है।
सेशंस फाइल मिल जाଉଛି
Hmm.
सेशंस कोर्ट फाइल मिल जाଉଛି
Session time अच्छा हो।
सेशंस डिसीजन सेशन जज फाइल मिल जाଉଛି ना ये जजमेंट एटा मिल जाଉଛି अच्छा मुझे तो सेटा
तो इधर connected है पिला।
ना ना मैं सेटा कॉल देखुଛି कि इधर
Connected है यारो देखो।
आज फिर देखुଥିଲି मैं हां 19 तारिख
IPC.
19 देखिए
The minimum prescribed. You can 2 years. What was the sentence awarded here?
5 years
5
I'll reduce to 2 years. What to do? And the period already undergone will be set up under section 428.
Right.
Set up this
for this
sentence,
one
whatever sentence.
The only difference the eyewitnesses are that they has to they have to be met. Since the eyewitnesses are there and the medical reports that has to be met while.
or that
But see, madam, it is the incident of 1988.
88
Today, we are,
Itself be a ground.
see, how many years, how many decades?
That itself cannot be a ground. My submission is that.
admittedly there are eyewitness to occurrence they have constant
That's it.
1 6 7 8 6 eyewitness there
Yes.
yes but the trial could also not well formulated the whether you have whether it's a case of 302 or 303 they have not formulated manner usually manner that is the paragraph 3 4 manner
But I am sure that if it is the case of 302, he might have been taken into custody. immediately. No, he was taken into custody in 26.
Shall the
20
defendant under section
22nd is the incident, 26th he was taken into custody. He might have undergone a substantial.
Because my lord, initially case 307 registered, subsequently after 22 days, my lord, the case converted to 302.
If I'll award
And here first time, my lord, 2 years first time remain custody.
2
And
years,
my lord,
then
20 days here.
it will be set up. Then he may not go.
20 days in the appeal period, my lord, remain in custody. Here, my lord, appeal period. Most time, my lord, since converted 302, most time, my lord, he remain in custody.
2 years at least.
My lord.
By reforming the conviction. Okay. Yes. Item 8, you had one.
My lord.
Yes.
8, my lord, I have not received the paper book, my lord. Sir, my associate might prepare it.
Now, they should be prepared in fact.
My lord.
See, these are the big matters in the sense sentences is more than 5 years. So,
Here, my lord,
little experienced lawyer should appear tomorrow.
here, my lord, the offense 307, conviction 307, and sentence 2 years, my lord.
At least 2 years.
My lord. In custody,
3 injury,
grievous, my lord.
grievous. Who is the injured witness?
PW2 and 3 years of injury also, there is a dying declaration also. PW6 is the before.
307 what dying declaration?
Before the PW2
That
was proposed before the PW6.
302 converted to
It was 302.
No, 307, right?
What dying declaration then?
That has been recorded before the video of PW6. The PW2 the injured has deposed.
Before somebody died, dying declaration. Huh?
I'm not saying it. But
that is 161 statement only.
They can be
Why are you expressing? You choose your words when you are a lawyer.
But the London trial court has clearly relied that the PW6 is the declared as a dying declaration.
How can it be?
That's
if
absolutely
further survive,
correct.
where is the question of dying?
Absolutely correct.
Read
But
section 32.
I'm not disputing your lordship, but facts remain from the bare perusal of the in judgments. The London trial court has stated that the statement of the PW6, the dying declaration also. That is there.
They have some cases saying that the 307 cases also are that is dying declaration. They have recorded since recorded.
Yes. Let us read 6.
Judgment.
He is injured. 6 is injured.
No, your lordship. PW2 and 3 the injured also.
Okay, let us see what are the injuries.
No, no question, madam. There is the judgment page, interval 7. In thus, a dying declaration by the accused 2 has been taken from period 2 by period 6 in the presence of period 9. Since period 2 has survived, the said dying declaration being not a substantive evidence. Your lordship,
That is not the substantive evidence, but
Section 32.
But that is not the substantive evidence. So the injury and
Come to the injury.
my lord correctly pointed.
PW5 lordship. That is the digital case of lordship.
PW2 is the injured.
Lordship.
Read it. What are the injuries? Let us see.
Lordship.
How many appellants are here?
Initially the charge that lordship.
One appellant, my lord, others
So
are
that-
acquitted.
So let me.
Then
Okay.
apparent along with
Who is he? Is it Vasudev? Okay. Let us see what Vasudev had done.
lordship my ID lordship.
I impressed Vasudev Mahapatra, Sarat Mahapatra, so and so.
I found my father.
Not to take father forcibly tied my father in a bag of veranda of Kusaka.
Padmanabha
Padmanabha Mahapatra got hold of the right hand. Sarat Mahapatra got hold of
knife blow.
left hand. Vasudev Mahapatra dealt a knife blow
Knife blow on my left chest.
on my left chest.
Lordship.
For the infliction of the knife blow, I remained senseless in the frontage of our house and regained. I refer to Jadpur Hospital also. Who is the next is P3, PW3.
3 years.
Knife blow by the appellant in the right chest. Okay. Next,
3 years.
I fell down. I went to the apartment in front of quarreling with my husband. I went to the road for the protest.
Vasudev.
Accused Rampa gave a push. I fell down and sustained injury. At that time, my husband was taken away. I was questioning Senapati. My husband was tied to a peg. Then that's so. I raised Allah. Many persons were there. My son Vijay came and accused Sarat and Rama. Got hold of here. Accused Vasudev.
Vasudev dealt a
Dealt a
knife
knife
blow.
blow. Same.
Chest of Vijay.
Next 5.
5 is the doctor.
Doctor, what does he say?
Staff, let's say,
Injury.
staff injury inside which is bleeding, 16 rib and pleura, cut along with the line injury with the surgical emphysema. The injury was situated in 3 below left nipple. Size of the injury was half inch and into 1/4 into half depth.
The injury might have caused by hard and sharp object. The injury of the injury is grievous. In sense when the hard and sharp malad, the intention must have not there to commit the attempt to commit the murder malad.
Aiming at 325.
And he is in custody malad. Total custody period 1 month 23 days. Up to 2 years.
So here is the PW2 and the 3. Those
Did
are
you
the
follow
intent-
what he's saying?
Yes.
What
that means set up.
Fact is intention.
If intention goes, it will
Therefore,
straight away come to 325.
Therefore, Your Lordship, the Lorentz
Sentence
trial court
under
is-
gone.
Therefore, the Lorentz trial court is in push 2 years, Your Lordship, and 3,000 fine, Your Lordship. Because on the grounds, the Lorentz trial court is in the intention on the present appellant accused.
Where, which paragraph?
That is, Your Lordship, but the Lorentz trial court, that is the judgment of the page 17, Your Lordship.
Para?
Para, Your Lordship, that part, Your Lordship. Six, 17 onwards, sir. 17 last per page 17 onwards, that last portion onwards.
To hard copy. So he, okay, sure. Follow. Yes. Which part you are saying?
That at the time of commission of the offense, accused 23 years of age, the imposition of the substantive sentence and fine are mandatory under section 30 IPC, taking the facts and circumstances of the case and the economic pattern of the society is which the accused is living, considering the compromise, station and record and the nature of evidence, that's very clearly nature of evidence, the accused is sentenced to undergo only RI for 2 years.
I am asking you, intention. Where is the intention to me?
For intention
No,
part,
why are you reading sentence?
the Lorentz trial court has imposed only 2 years, taking with that the period of age of the appellant.
What he is arguing is something different. He is saying that if there is no intention to cause murder, therefore it could be a case of 325.
That's-
If 325, he is saying that he is already undergone substantive period. So where is the finding to that effect?
That
And the story of the prosecution matter, read out the matter the judgment matter, page 2, paragraph 1, towards last 3 lines matter. At this time of the accused 1, accused 4 Kothol Vijay Kumar Panda, Banshidhar Panda protested. Accused number 3 dragged Banshidhar Panda to the cow shed of Krishna Senapati. Accused number 1 dealt a knife blow on the belly of Vijay with a null.
The other people were acquitted because they have participated.
They have participated Kothol also. my lord.
Patrolled also, but
Only because my lord, he has gave a knife blow on the chest, but for that reason he has been convicted, my lord. But as support of the co-accused persons, he has committed the assaulted, my lord. The
34 was there. They should
injured.
have been also convicted.
They have been acquitted, my lord. In fact, my lord, there is no intention to cause the, my lord, the injury into committing murder or attempt to commit murder. Only intention to assault, my lord, to the deceased. So, my lord, 307 is not made out, my lord. When there is intention not there, my lord, only to assault, in order to, my lord, there is a quarrel between 2 groups, my lord, in a piece of land, my lord.
EW2 is the injured witness.
No.
Come to page 9. Page 9 of the impugned judgment. Page 9, just read in between. Defective investigation by itself is not the ground for throwing out the prosecution case. According to PW2, read it. According to read it. According to PW2.
PW2, he was assaulted below the Honda of his
Pinda of his house.
Pinda.
And not on the road.
House and not on the road.
According to PW7.
He had not found blood stain mark on the place of offense. Common human conduct is to person, the injured person of the body, which was
Press the injured portion of the body, and which has been stated by PW2. And this part also not
In addition,
not in addition to
in this court.
this court. The facts and circumstances of the case,
found it
as is the mess, has been found that intrinsic corroboration in the evidence of PW1, 2, 3, that PW1 is not an eyewitness to the assault. PW2 and PW3 has not specifically stated that PW2 was assaulted at the initial place of assault, that is the road in front of their house. The distance from the edge of the pinda and the frontage of frontage over the road has passed, has been elicited.
Page 11, paragraph 13, madam. The affair reveals that PW2 was dealt with the knife blow on the belly as per affair, madam. PW1, 2, and 3 have attributed that the dealing of a knife blow was on the chest. So there are affair story difference, madam. Initial affair laws, madam. As per affair story, it is stated that he assaulted the belly. But other witnesses, eyewitness present, they have stated that the 1, 2, and 3, they stated that the petitioner.
Who is the doctor? Who is the doctor?
There is five is the doctor, and another PWs are those who are treated to the PW2 and 3 also there. PW9 and 10 year also. 8 and 9, sorry, 8 and 9. So treated to PW2 and 3 respectively.
The Don could clarify that the injury between the belly and the chest.
So therefore,
On the other injury,
the FIR they say chest, witnesses say the belly, then it must be in between somewhere. Exactly those things will not come on evidence.
intention manner is clear the case manner for intention is required, my lord. Whether he has intent to
That part only I am searching.
Right.
Yes, prosecutor, you tell us. Intention.
Intention, but then kindly glance the PW6 statement also. The before whom the PW2 and 3 is the deposed also.
Yes. Which part?
Let's say I'm for the doctor, let's say that I'm reading the dying bed in from the beginning also. I took the dying declaration of the Vijay Kumar Panda and Bansal Rabirati, who was
What do you want to say?
but I am saying that the accused person has gave blow to the right chest of the present PW2 also.
Admit it.
I mean, that is try to bring the know that the PW2 and 3 is clearly deposed for the PW6, and in their evidence they clearly stated.
Still you are not answering what exactly.
Intention part, you also. Intention part, so far intention part is concerned, there is no materials regarding that there is any to commit murder, there is no clear evidence is there.
Converted to P24.
the murder is even custody.
25 also.
1 month 46 days that set up. And fine amount maybe enhanced so that he, the injured will get some.
See, the incident happened when 88.
Married. 80.
88, then what was the sentence here?
2 years. Sir.
2 years.
2 years, fine rupees 3,000.
Already undergone period?
1 month, 23 days.
During trial, you haven't.
24 days.
Even during trial.
Married.
Have you checked it?
Married. Date of arrest, date of release.
When he was arrested, let us see. Right.
18/11/88 ରେ arrested. 12/12/88 ରେ bail ହେଲା, 24 days.
Then in trial court, huh?
Married.
18/11.
18/88 ରେ arrested.
18/11/88 arrested.
12/12/88 ରେ bail ହେଲା, 24 days.
88 bail. And after conviction?
And after judgment ହେଲା 4/3/92.
This court granted bail when?
What happened in this case, my lord? Interesting, my lord. Instead of filing appeal, the council who has conducted the case filed revision, criminal revision. That he has religion bail in the revision, criminal revision here, my lord, by this court. Subsequently came to know appeal has to be filed. Then it is converted to appeal. That I am doubt was revision just bail raise. The Kadin Pala has a
But here the appeal paper will be here.
This is the
Yes.
he mentioned criminal revision, my lord. Thereafter.
Then he was granted bail. He was arrested. No, when the judgment was pronounced?
Judgment, my lord, 13/92.
And no.
Say revision jana padibo je kedin rahiche.
No, when the judgment, trial court judgment is
13/92 judgment.
Can't be. Because in the proceeding,
Top of the man,
the proceeding says 4/3/92. Let the petitioner be released on bail. Same day.
যেহেতু 2 years conviction ଥିଲା lord
Say revision ରେ bail ଯାଇକି.
revision
Subsequently convert ହେଲା appeal.
ନା ସେ ଯୋଉ
Top ରେ ଲେଖା ହେଇଛି.
But at the same day revision was filed. The day when the judgment was pronounced in the High Court.
initial
Can't be.
conviction 2 years ଥିଲା lord trial court has granted bail lordship during the date of pronouncement judgment lordship 2 years ଥିଲା ଯେହେତୁ ତାପରେ ଯେ inadvertently criminal revision approach କରିଲେ
criminal revision 140
389
92 criminal revision file ହେଇଛି.
No, the revisional court might have regularized, but I am wondering the date. The date, just see.
92. 92 judgment 92.
4th March 1992.
92.
And now they see the proceeding. Proceeding.
Here in the man this file manner.
Just see the proceeding. 92.
Proceeding manner 3492. Ask case appeal file on 12/3/92.
There is a proceeding. Just check it up.
But this manner here manner holding manner the revision file manner. Initially it was a revision. Subsequently manner.
Just see proceeding dated 3/4/92. There is a proceeding. Just see.
Here manner.
No, it's there. I'll show you. 3/4/92. On the same day, how could there be a proceeding here?
Revision rate order type.
No, I know. I understand it.
Revision bill.
That's right. See this proceeding.
No.
On the same day when the judgment was pronounced in the trial court, how the revision was here?
4/3.
Huh?
4/3.
3/4. देखो भैया.
4/3. এটা 3/4. 4/3 मार्च जजमेंट.
4/3.
Sorry, March.
এটা 4/3
अच्छा ये 3/4. And 4/3. But he might be on bail because 389 minutes.
हाँ bail जाते हो. 24 जा 24 days.
So
Let the petition release.
undergone period will be very less.
Fine amount enhance packet so that the injured can, if alive, well, he can get. Otherwise, he will be taken into custody.
Fine amount.
It is not a case under 307, my lord.
It's not a
Maybe-
case of 307.
trial court is ସେୟା କହିଛନ୍ତି.
Huh?
Trial court has directed the relation of fine of 500 rupees goes to the PW2 as a compensation of the injuries. sustained by him and under section 357(1) of the CRPC.
500 in the year 92.
At that point of
92
time,
is,
at that point of time,
Today that will be equivalent to
at that point of time.
25,000.
The fine the state was in
Shall I increase the fine to 25,000? Already undergone period already undergone. About how much he has already undergone is total
24 days আছে
24 days.
during course of investigation. Punishment 18, 11, 18. Religion.
What was the age of this petitioner? Was the
Judgment লেখা আছে 21 years old also.
Just check it up, the charge sheet.
23. 92 ରେ 23 ହେଇଥିଲା 92 ରେ ବର୍ତ୍ତମାନ 92 ହେଲେ 33 ବର୍ଷ 33 ହେଲେ
Judgment age had not been mentioned.
ନା ଏବେ ତ ଜଜମେଣ୍ଟ ରେ ଲାଷ୍ଟ 17 ପେଜ 23 years ଲେଖା ହେଇଛି 23 33 ଯଦି ହବ 56 years also.
43 years.
Now 56 years also.
Accused statement, just see accused statement.
I'm not certain, but from the judgment will also
Accused
check it.
statement you get it. What is his name? Padmanabh. Vasudev. Just see accused statement. Here also it's not. The format also they do. Age about 25 years. 25 years. 25 in the year 1990. So now he must be around.
60.
Hmm?
60.
60 years. Increase the fine to 25,000. 25,000 and period under.
If the fine will not be realized, then in suffer.
Default another 2 months. But the problem is, I'll tell you, there is a, see, if the substantive sentence is whatever substantive sentence you give, and thereafter fine, default fine cannot exceed 50% of the substantive fine.
There are the judgments. Experts.
Suppose I say already undergone, 24 days is already undergone. Thereafter, I increase the penalty to 25,000. Default fine cannot exceed more than 12 days. Because substantive sentence is 24 days. So that's the biggest problem.
So, since knife injury, chest injury, they are using that happening.
That's very difficult to balance. Just imagine he would have been died. Injuries are serious injury. Somehow he saved his life. Chalo, dekh. What I'll do is 1 month sentence. Why 1 month sentence? I'll tell you. You get remission. About 4 days remission as it is you are getting. 4 days remission means it is up to 26 days. And you have already undergone 24 days. So 15 days in default sentence I can remove. So that is how I will manage it.
Is that usually the doctor's evidence there, I have to say evidence there, I can't manage to get to it.
No, had it been a case, it's not an old case, this is a case for conviction and upholding the sentence of.
Both the cases.
But for the incident has taken place long back, what to do? 92 appeal, 94 appeal. Appeal 94.
92.
appeal 94 ಅಲ್ಲ 92 ରେ ಫೈಲ್ ಇತ್ತು
90.
ರಿವಿಷನ್ करतले ಫಸ್ಟ್ ಇನಿಷಿಯಲ್
Yes, को लगा दो. Yes, anybody is ready, I think.
Item number 3, may I just add?
Yes.
I'll just place one judgment. Your Lordship, I
Three,
want
three, what happened? What did I do?
which Your Lordship was reducing the sentence and
For 2 years?
yes, sir.
Yes.
I'll just place one judgment.
You want enhancement?
No, no. So I'll just place one judgment.
Regarding what?
The reduction of sentence on the ground of pendency appeal is not permissible.
On the ground of?
Long standing of appeal is cannot be a ground for reduction of the sentence unless there is a question. My endeavor
It is only ground.
I'll just place it.
Then in all the cases, then I'll have to send everybody to jail. That can be a ground. If it is pending, which part you are?
Para 9 years.
Para
9 and 10 I'll be placing. That the equivalent citation is 2022 12 SEC 166 years.
And 2015 93 appeal.
Yes, sir.
93 criminal appeal. Okay.
Place,
Which paragraph?
Paragraph 9 years.
9.
Yes.
Yes.
10 line from the top. I'll
Yes.
start with the learned trial court.
It was a case of 307.
Yes.
Yes.
May I read? The learned trial court sentenced the accused Banwari Lal to undergo 3-year rigorous imprisonment. Therefore, as such, the learned trial court have already taken a very lenient view while imposing the sentence of only 3 years arrived. Therefore, the High Court ought not have interfered with the same, though the High Court has not stated anything from the impugned judgment and the order passed by the High Court. It appears that what weight with the High Court is submission of on behalf of the accused that the occurrence of the incident took place on 31/3/1989, that is about 26 years old ago, that they were facing trial since last 26 years, and when the occurrence took place, they were young and now they are aged persons. The aforesaid cannot be the sole consideration while awarding an appropriate or adequate sentence. Even with regard to the submission on behalf of the accused, there is no minimum sentence under 307 something. That may not be relevant.
What was the sentence?
And the sentence has to be imposed proportionately and looking into the nature, gravity of the offences committed by and by considering the principles for imposing such sentence referred to herein above. Therefore, over the page is the paragraph 10. Merely because, may I read?
Yes. Read it.
Yes. Merely because a long period has lapsed by the time that appeal is decided cannot be a ground to award the punishment which is disproportionate and inadequate. The High Court has not at all adverted to the relevant factor which are required to be while imposing appropriate suitable punishment or sentence. As observed herein, the High Court has dealt with and disposed of the appeal in a most cavalier manner. The High Court has disposed of the appeal by adopting shortcuts. The manner in which the High Court has dealt with and disposed of the appeal is highly deprecated.
See, these judgments are, it's all right, but see, the problem with us is,
My whole
see,
endeavor.
our jurisprudence is running into concept.
Yes, sir.
One is reformatory jurisprudence. We have reform by giving the opportunity to lead a better life in the society.
Yes.
And you allowed him to lead for 30 years in the society. And he reformed.
I may not
Presumption of
be-
reformation is there.
Is there.
And second is, the biggest problem with us is there is no sentencing policy.
Yes. Sir.
And in no other country will find such a range. It will be extended to 10 years. It starts from one day to 10 years.
My whole.
Such a discretion if you give in the absence of a policy
Yes, sir.
for the purpose of imposing penalty, this situation would be there always. Case to case you have to deal with.
Lucia, my whole endeavor is to say there has to be some description of the evidence in the appeal so that it can be done. My whole endeavor is this.
It can be.
I mean, the judgment which your lordship is intending to pay your lordship, it can be done in a different manner.
What you intend to say is,
There has to be
while
some-
imposing penalty, don't only consider the
Yes, sir.
this thing and
Yes,
the other
yes.
part also you
Yes,
have
sir.
considered.
Yes, sir.
Other
So that
part
it
what?
should be a sustainable.
Other part what? It is a case of conviction. All the eyewitnesses have deposed. There is an injury, single blow injury. And doctor also says that fact I can't change.
Yes, sir.
For the purpose of sentencing, the only factor is the incident is 88 and he was the,
In their statement, the accused what have stated like the deceased and his associates attacked the accused persons, and while attacking, the bhala accidentally went into the body of the deceased. So that can be a factor which can be
Bhala has not been
Yes.
seized.
bhala has no. So
Not
these
produced, not
factors
seized.
can be. I mean,
but the
And that after 20 days.
injury caused by Bhala, that has come on record.
But the IO stated in his evidence, Schedule 4, the Bhala can cause disability. 1 line may have a read out manner, pointed out by the time. Had there no definite opinion given by the doctor.
There is a
that
doctor-
Bhala, the injury caused by the Bhala. That is
Doctor
not.
has said, PW6 or so.
But
the
line
PM
PW
doctor has said.
PW 4 ballot.
Four,
PM
four.
doctor, yeah.
In cross section, he has stated
But
that
PW3 says
The
that
first
it's caused by Bhala.
213 said that
in the absence of ballot, the weapon of has not been seized and no diagnosis recorded. 22 days after the occurrence, he has died. But these are the person. Here, my friend.
Have you
judgment.
received any injury? You.
no.
No.
Hmm.
But there, my lord, the Honorable Appeals Court stated that High Court has not stated anything. Here, Your Lordship clarified many things, my lord, while going on arguing.
To
There, my lord,
to apprise the lawsuit, but cannot be done.
sentence part, not saying anything.
But
For
there
that
are
reason, my lord,
there
I'm
are
not-
1001 judgment contrary to this.
Yes, Your Lordship, I'm not.
There are other
here.
judgments are there, my lord.
My kind
Any
answer.
judgment.
Any judgment.
I'm just trying to facilitate the court to be what is to be done in a much fairer way. That's it.
But see,
My lord,
for sentencing, these are the only factors which can be taken into consideration. The age, health of a person,
Yes, sir.
and
And the endeavor of the accused person.
these are the. But the judgment is going in a different tangent.
different.
Tangent altogether. But we don't know what are the facts of that case.
Each case, my lord, the fact and the circumstance in each case are different.
So he has given the trial court has extended the benefit of 360.
Yes.
Therefore, by extending 360, the trial court says that 44 days undergone, so therefore it suffice.
Yes.
Therefore, the court says this.
Yes.
But here I am reducing to 10 years to 2 years.
So minus
2 years.
They just would like.
2 years.
इसको उसी के साथ
Yeah.
रखें. Okay, I think we stop it here.
Madam,
Further-